we have with us a presentation, just like I hinted, during divine service, of where we are having and tackling on the issues of ADR, because we appreciate of what the preacher was saying in the divine service, that Jesus Christ was sent to all of us to set us free. And these very laws of these countries, and in Kenya in particular as a jurisdiction, is there to set us free. Some of us have been held in cases and in things that we wish to set ourselves free. One of the mechanisms we are saying this afternoon is the ADR. And when I'm saying ADR, I'm saying alternative dispute resolution. We are so used to the idea of going to court. We argue, it takes time. At the end of the day, it takes years, it takes ages before we get the justice. Some of us, we don't get the justice that we desire. And the people that we will apportion the liability or the complaint is again the advocate or the lawyers who've been handling the cases. But this afternoon we are saying there is a route for us as Christians that we can engage in and we resolve our disputes amicably. And that is the discussion I want us to have this particular afternoon, so that it informs us when we are having disputes. Do we have to go to court all the time? Do we have the patience to withstand all that happens in a court setup? Some of us do not have the time, but we wish to settle and finish as soon as possible. Especially if you're dealing with corporates. Corporates will not want to go to court and take all the time they would want. They will need as shortest time they resolve on a matter. And therefore, allow me to invite us to this presentation. With me, I have my colleagues here, and I believe we'll be able to tackle some of the things that can come out of this particular presentation. Allow me to pray, and then we will have this presentation. Then from there, we'll have the answers and questions session. And then from there, we'll invite the speaker to summarize it up. We are praying. Father, we thank you for the opportunity you've given unto us. We thank you for the physical food that you've granted unto us. It's another opportunity once again. We wish again to enlighten ourselves on matters pertaining the laws of this country. We are citizens, yes, but we pray that we should be law-abiding. And there are matters relating to law, matters relating to disputes, that, Father, you have brought your information to us. Give us your understanding as we embark on this presentation. May your will be done. For this we pray, trust and believing, through the powerful name of Jesus Christ, I do pray and believe. Amen. With me, I have Brian. With me, I also have Peterson. Allow me to invite Peterson to give a brief of what we are discussing, just in a brief sense. And then from there, I'll invite Brian, and then I'll come after them in the few minutes that we've been given. Thank you. Peterson.
Good afternoon. Good afternoon. I want to take this opportunity to welcome you back. I don't know if I'm audible enough. Can you hear me from the behind you there? Good. Yeah, as Senior Callaghan has initiated, this afternoon we want to have a concrete discussion on a topic that he initially stated, it's ADR. Someone in the morning tried to get the meaning of ADR, and CJ told him to come back in the afternoon so that he can be able to get the meaning. When you talk about ADR, we mean alternative dispute resolution. Alternative dispute resolution. Those are three key distinct words that I guess at the end of this small discussion that we shall have, even before you ask the questions, we will be able to redefine that word and get it another meaning probably. Normally, where we generate issues or when we have disputes, we rush to courts. You'll either pick an attorney to represent you in a case, because we live in a society that is not governed by angels, neither are we angels. In that perspective, I mean that we are not peaceful and we are not perfect. There's one way in another that you'll be able to quarrel with your neighbor, either consciously or unconsciously. You can decide to live a very peaceful life, that you don't talk to your neighbor, so that you don't initiate a wrangle, right? Is that what we all aspire? To live at peace with our neighbors. But now, a problem will get you even on the road. You'll be driving carefully, then you get an accident. You knock someone down. A dispute has arisen. Probably you'll be a good employer. You develop a company with an intention of creating employment to people. As it works, a certain employer starts stealing from you. What do? You tell the watchman, I've sacked you. But have you followed the right procedure? That person will find a niche, you will rush to courts. You are a good doctor, taken all your professional courses very well. You are employed in a hospital. So in your mind, you're doing what is known as a best duty of care to the patients that you have. But now you've forgotten that you had a stress in your family. As you are suturing the patient, you forgot a gouge in the stomach of a patient. What does that mean? Is that not a dispute? A dispute has arisen. The injured party will rush to court, right? And from there, a case has arisen. When we mean, what do we mean? I know you all understand what we mean by going to courts. We have different courts in the Republic of Kenya that are established under the Constitution. From the top notch, we have what is known as the Supreme Court, followed by the Court of Appeal, down to the High Courts. Then High Courts, we have Magistrate Courts, and then we also have other subordinate courts, in which we can classify some 2 to 3 specialized courts, like the Kadhi courts. So that is the channel that we take our matters through courts. So when a dispute has arisen, you'll be able now to be advised by your attorney or the legal department on where is it best suits for me to take certain action. The dispute that we are normally classified are the things we call the cause of action. The dispute that is in between the parties. So whenever there's a dispute, you are advised on which way or which category of the courts should I approach for my dispute to be resolved. For example, I've talked about the issue of an employer relegating duty to an employee. That matter will go to an employment and labor court. We have other issues that we have over land. It will go to an environment and land court. But now today here we want to talk about what are these other things we called outside court settlement of disputes, and why should we embrace them? I know in your thinking, you can be thinking like, will justice be served when we give someone else, when we are away from a judge? Will I be able to get justice? But the other question that now I want to ring in your mind. Before you go to court, I've told you that you'll have to get a lawyer, right? A lawyer will have to prepare for you documents. And even before we begin that, remember there's that aspect of classification of your dispute, done through consultation. What comes in your mind in all the 3 things I've talked about? What comes in your mind as a disputant, as a person with a dispute? what comes in your mind? What should you have? What should you have? It's a discussion. Because I want us to understand. You have to appoint this lawyer, but before you appoint the lawyer for him or her to be able to take you through the legal process, what must you have? Money. Yes, you say it loud. You must have money. As CJ told you that today you'll get a free consultation. It's not a must that it's not an office that you come and they say before you see a lawyer, you live with the secretary. How much? 10,000, 5,000. So there's this aspect of money. And I want to tell you that many people normally fear court processes because they believe that they are very expensive. And it's very true. Take an instance of that employee who has been sacked by the employer. In fact, the first thing, he has not been paid. He or she has nothing, probably. He was expecting for an end month to get a salary, but he has been told you have to go home. You will have to think, should I sue my employer? And remember, the employer is a boss. Probably a person working in a government, a person with heavy financial muscle. So this lady or gentleman has other options. Should I pay for my child school fees for the little that I have, now that I don't have any secured job opportunity? Will I buy food for my family? Or will I take it to lawyer Callaghan to represent me in a court so that I can sue this big man with big financial muscle? Do you see the kind of problem that this employee is being faced? He becomes like he's now in a quagmire. He doesn't know what should I do. That's why today we want to bring this to enlighten you about what we know as alternative dispute resolution. When that word clearly shows that we are trying to get something other than the normal court process. That is the word of alternative. That is the meaning of the English word alternative. What other ways should I use as a person who has been aggrieved so that I don't go into this rigorous process? Yes, Elder? Yes. Yes. Employer. Boss. Yes.
Even if I went in for an alternative dispute resolution,
Yes.
I'm still coming from that disadvantaged position. I mean, the well-oiled boss or the wealthy boss will still have his terms. He will still have his way. I mean, my bargaining power is so low, so that going the court way, going the alternative way, I mean, I'm still at a loss.
Good. I think I'll be able to bring that into a very nice illustration so that you'll be able to understand. I want to first and tell you that, remember, the common thing here is a dispute. And I've told you disputes are classified differently. We know that the cause of action. It can be family, it can be land, it can be employment, it can be accident, medical negligence, all those. Anything that you find that actually you are in a dispute between one and two other persons, is that what we call a dispute. It is common, even when we are approaching alternative dispute resolution. But now, the question is that why should I employ alternative dispute resolution other than the normal court processes? That is now the question. And because I've told you, money is one of the common factors. The question is, we have a market, right? There's a cloth, for example, a jumper, that costs 500 shillings. There's also another one being sold in a high-end shop that goes at $1 million or $100. Now that brings the distinction between the two kind of jackets. But by the end of it, you must have something to put on, right? Whether you are, the way you acquired it, okay? The final product that you wanted something to put on. But how have you achieved it? Normally, there are several kind of dispute resolution mechanism that are well advanced in Kenya. And it comes from the basics, like number one, negotiation. Number two, we can have mediation. We can also have inquiries. We can have traditional mechanisms. We can also have ADR. We can also have arbitration. So what are these that we called alternative dispute resolution mechanism? What is an inquiry? Can someone just in a basic layman language, what is an inquiry? Mtu aeleze tu vile anajua. Mtu akwambie like I'm just doing an inquiry. What comes in your mind? In light that, put in mind that there's a dispute. But I've decided to do what? To do an inquiry.
My non-legal background tells me it will be something like asking in such a situation, what are my options? This and this has happened. What are my options? How does the law favor or predispose? Does it stand on my side or not? Just an inquiry to know my position and the options.
Good. Basically, I began it from something I told you about, consultation. In your mind, once you have a dispute, you always believe that I am on the positive side. I'm the one who will go to court and win, right? I'm the one who has been wronged. I will just use the clear example that we have of an employer and an employee. The reason why this heavy boss, as elders explained, decided to fire this employer, for example, a teacher, is because the teacher was absconding classes. The teacher was coming late to class. I think in this country you saw a minister who was arriving in class or in schools at 7:30, expecting classes to begin at 8. Some teachers will be driving to school at 9:30 with no hurry. They will come, even see the students in class, don't give assignments. Then this teacher is sacked. What will be in the mind of this teacher? I will go to court. The TSC will do what? Will pay. But upon inquiry, you can inquire probably even through lawyers. You will be told you are the one on the wrong. That was the teacher will be told. You are the one on the wrong. What was your breach? You came late, absconding of duties. Will there be a dispute there? Will there be a dispute? Or has the possibility of being a dispute resolved? If she will be told that you are wrong, answer to the notice to show cause, give reason why you came late, probably I was taking my child to school. Get the repercussions that probably will be there, you'll be suspended for 2 weeks and brought back to work. Do you see how that dispute has been resolved? What could be the alternative that this teacher will have taken? Employed a lawyer, a very serious lawyer, like the people I know you see some people in the TV. Get a television, give very heavy statements that the way TSC is going to get a very heavy penalty for sacking a teacher. Probably I know teachers, you have classification. So probably it was a chief principal who has been suspended. So actually the lawyers or the society generally expect that this person will have heavy and hefty compensation. But upon doing an inquiry, getting to understand what was the cause of action, you'll be able to see that actually that issue will have been will be resolved amicably. Have you understood the aspect of inquiry? It is just basic consultation. Ask, what has the possibility of me doing A, B, C steps? And you'll be able to find that actually a dispute will be able to have been resolved. Another example that where inquiry normally falls in is whereby an elderly person walks into an office of a lawyer, or he goes and actually says that I have 1, 2, 3 properties. How do you think I should go about it? Then the lawyer will actually tell him, let's do a will. divide this property among your children in this manner, write for me a will. An inquiry has been happened, it's a consultation, something has come out as an end product. The end product is a will. How has it become an alternative dispute resolution? Normally when people die and they leave their property, we call the estate of the deceased. For you to get this estate divided to the beneficiaries, it takes a rigorous process of succession. The course of action is, after death, you choose a succession case. Succession case, they are very expensive. But they are appropriate, but they are the only way for you to transfer the estate of a deceased person who never wrote a will. We call that he died intestate. He never left anything written that this is the way I will wish my car to be transferred to my son Kevin. He just left. The way death is uncertain. How was that inquiry that led to production of a will? How has it solved the dispute? Can someone answer to me so that I see that we are good before I close on inquiry? How has the will reduced the rigorous process of litigation? Any person? Okay, we'll continue. I'll probably explain. It has reduced the cost that this family could have taken to go into court, get an administrator, from there go to court and resolve the issue. And you can never tell, because if someone say that actually dad was to leave me 10 acres, then another child comes from somewhere. Peter was also my father. You cannot take 10 acres. I also want 5 acres. You see the way a dispute has arisen. And who is the beneficiary when there's a dispute? Who is the beneficiary when there's a dispute? Yes? Lawyers? Who else? If there's a dispute, each and every person will benefit, right? If you are a person selling mandazi near court premises, will clients not be walking into courts, having hefty time hours in court, and then they'll be coming for something from your canteen? Will you not be a beneficiary, right? Whose money is being spent? Litigants' money. This money could have been used in something else. So I'll be explaining at the end of it the advantages and disadvantages of ADR. I want you to understand from the source. I think we talked about money, but I want you to understand when I tell you that ADR is cheap. From the initial example that I've given, I think it will be able to bring a clear picture. Okay? Yes, Brian?
Happy Sabbath. Happy day. Peterson is being a bit economical with the truth as far as money is concerned. There's something called advocate's remuneration order, which basically prescribes how much an advocate is allowed to charge for a service. You understand? So what you need to understand is that even if this advocate is your son elder, there is a certain minimum that he can charge you. Because if he charges below that minimum, Peterson will go and complain that there is someone who is watering down our services. Now, what you need to understand is that when it comes to a matter like succession, as Peterson has said, it's quite expensive. A percentage of we call it an estate, a percentage of all the inheritance will have to be paid out to the lawyers who have represented these families. Do we understand that? Notice I said lawyers, because you see, Peterson, who's probably my younger brother, goes and gets a lawyer. Me, I get a lawyer. The neighbor who says the child is also from this home also gets a lawyer. Are we understanding what is going on? So we end up in this situation where something that was preventable creates an unnecessary complication. Number two, there's the other point of the legal system that we operate under in Kenya and all Commonwealth countries. We operate an adversarial system. So it's a system that is designed to ensure that one party wins, one party loses. One party. And what almost always happens is that one party will usually win the case and all the benefits of the case. The other party loses the case. And in some cases, the other party is actually directed to pay both lawyers. Did you hear what I said? Yani you pay Peterson who was on that side, you pay my learned senior who was on this other side. The costs are assigned to the one party. So the reason why ADR is critical is for us to understand that there are preventive mechanisms in law to allow you to resolve your issues before they come to court. And that is why then it becomes important, even for a disgruntled employee, to seek an alternative dispute resolution mechanism before going to Peterson. And by the way, Peterson will happily go to court. If you tell me to go to court, I go. There's nothing preventing me from taking your money. Do we understand each other? Yeah, so let's then consider that ADR mechanism. Thank you, Akili.
Thank you. I think we'll be able to understand the, I'll give you a point first. Let me finish. Let me give the highlights of this nature of alternative that we have before I invite questions and probably give example. We've talked about inquiry. Another one is negotiation. And I want you to understand this thing from the basic that they are. Negotiation simply means we talk. Invite the party that you feel has aggrieved you, okay? And the person that you feel is actually has been aggrieved. Let's sit down as two people. Not inviting any other person. Let us talk, okay? An employer getting an employee, like, hi boss, come. What was the issue? Why did you feel that I should not have sacked you? I think normally in medical areas, doctors I normally see, we sign something called notice to show cause. A very senior doctor being served with a notice to show cause. Come and show why you are not at the general wards. You are during your working hours. You're operating your clinic in town. Right? I think most of you are able to see such instances. So whenever there's a negotiation, it means two people who feel they have aggrieved each other come and sit down, and then they find a solution to their problem. Another one is called mediation. Now, mediation is actually one of the embraced system of ADR that we have in Kenya. Kenya, through the Constitution, through Article 159, has actually employed upon the judiciary to employ these other dispute resolution mechanism. And mediation become part and center stage of resolving court cases. In mediation, we get someone called a mediator, a neutral person who will be an interlink between the disputants that will be able to listen from both parties and be able to advise. Get that clearly. The role of a mediator is to do what? To listen and to advise, to guide people into resolving their issue. I don't know if that has gotten home. Is that information at home? You get a mediator, a person who is a neutral person, who listens and advises the parties on the best way to resolve a dispute. I'll go now back to succession. I'll give an example. How is mediation helpful in this area of succession? We've been told succession arises from an instance whereby the estate owner, who is now deceased, left a junk of property. In his mind, or even in the mind of the church, Peterson had only 2 children and a wife. How many beneficiary for Peterson? How many beneficiary? 3. So if Peterson had 90 acres, he did not decide. In the best interest of justice, we'll say for the 3 beneficiary, each person to go with equal share. The wife, 30, first son, 30, first daughter, 30. And that dispute will have been dissolved. We'll be able to share the dispute of the property of the estate of Peterson. But now here comes another lady from Kisumu who come and looks exactly like Peterson, who has a daughter exactly looks like Peterson. He claims that I'm also a daughter of Peterson. Does it bring a dispute to the already known mode of distribution of the estate of Peterson? He had himself as a 4th beneficiary. How will that be resolved? If they go to court, after all, it will be very rigorous. The court will have to analyze very critical issue. But now, if we go to mediation, we get a mediator who brings these relatives of this other mother and then they come and sit. And then anauliza, wewe mama unasema huyu kijana ni ya Peterson. Evidence iko wapi? Anatoa picha. Kwanza kitu cha kwanza anatoa birth certificate. Pale hivyo mali inakuanga imeandikwa father's name. Ni jina zote za Peterson, jina 3. Anaenda anatoa picha zingine. Peterson akiwabeba na gari kutoka clinic. Si ndio? Anaonesha. Another issue anaonesha kumbe Peterson alifanya in Lowland we call it nyombo. Alifanya nyombo in the secrecy behind the original wife that the church knows. Are you getting how the dispute has arisen? Are we getting now how a mediator is resolving this dispute? He's getting all this evidence. Mediator akikaa chini ana advise the initial beneficiary of Peterson probably and the relative, anawaambia hii mkienda kotini hapa hivi wenyewe hamtaweza. The truth is this fourth child belongs to who? Peterson. Kaeni chini muagree mseme mtampea eka ngapi. Then the relative after wameona yenyewe it is overwhelming wanasema what we'll do, mama kwa ile eka yako tutatoa 20 tutapea ukijana. So the mediator advises these people to do the same. Then they say it's okay. So the first son was getting 30, anapata 20. The other daughter was getting 30 also, anapata 20. So that by the end of the day, this other child has been catered for. And they get approved. That dispute has been able to be resolved. Now look, what is the other way if they could not have resolved through a mediator? It could have gone to court. The court could have called for DNA. Peterson was already buried. What could have happened? We need a DNA. Have you heard of body being exhumed? How emotional is it? How emotional is it? As a church, probably you contributed to the burial. Now you're being told there's a dispute. We have to resolve A, B, C. We have to go back to Kisii, exhume the body, be taken to government chemist for examination. Is it not tormenting? But you see the position of a mediator in that dispute has been able to resolve it. So be able to understand that mediation brings a neutral party who comes, listen, and then be able to advise. He does not advise something that is conclusive, or we call it binding. He just advises. Then it is for the parties who are negotiating to weigh, are we agreeable? Is it something that we can buy? If not, the matter goes back to courts, and it goes back to the rigorous process of courts. Okay? Another one, we have conciliation. I think most of you have been, even in church, we normally use this mode as a way of resolving disputes. Conciliation, whereby where there is a dispute, family issues, we bring an elder comes, talk to people, counsels them, then by the end they find what? They find a solution. Another one, we also have arbitration. Now, how unique is arbitration from all these other ways? In arbitration, remember, we are not in court. These are party. We normally use a legal language called party autonomy. What does that mean? The individual, the disputants, are at liberty to select the person who they will wish to resolve their issue. And even after selecting a person able to resolve the issue, they hold the superior power of making a decision that will be a determinant to resolving their issue. That is what we call party autonomy. I think it will be good if I give it with an example of now, the other normal legal process. When we go to courts, the lawyers will be advising the bench, or probably the judge or the magistrate. Each and every person, as Brian has said, it's an adversarial system. So the lawyer of a party A will be speaking on the superiority of his client's case. The lawyer of party B will also be speaking on the superiority of the party B case. Why should my client win this case? The other party will also be, why should my client win this case? Okay? Then the decision now will be on the hands of who? The judge. Is the judge now will come and say, but I see even if you sacked this person, you are the person on the wrong. Yet the teacher was absconding duties. But now the judge has said, you are the employer, you did not follow the due process of sacking this person. So for the damages, I want you to pay this teacher 5 million. Have you seen how that is a complex system? It is the judge who is giving a determination, will you say it is unfair as an employer? Will you say, actually, you sacked the teacher because he was absconding duties, but now the judge has said you didn't follow the due procedure? That is what the judge said, but that is what will be followed. But now when there's an arbitration, each and every person bring the dispute beforehand. Okay? They get this person called an arbitrator. An arbitrator is different from a mediator because he will have a final say. But remember, parties have not been denied what is known as party autonomy. It is still the parties who have the final say on how their dispute should be resolved. If this employer says that actually, we mwalimu ulikosa kuja darasa siku fulani fulani, mimi naona for me to resolve this case issue, sita kulipa ya mwezi mbili, alafu rudi kazi. Okay? Na mwalimu aseme yenyewe naona nilikosa kazi, I apologize. Nisamehe. Kwa hii makosa ubadala ukate 1,100, kate 50,000, kate 50,000. Alafu ambia arbitrator. So the arbitrator will say that actually the teacher for absconding duty will be punished for 50,000. So in arbitration, this other third party that is introduced in a dispute has what is known as a binding resolution. Whatever you will say, generated from the parties' issues, will become a final answer to a dispute. Okay? Another mode that we have for dispute resolution, nile awaze. We call it the traditional dispute resolution mechanisms. I think it is very common even in our families. Okay, example, in family disputes, we'll have that, baba nani alipiga mama nani, so mom akaenda kwao. What happens? What happens? Elders from, or wazee from this other family will join hands, get transport, buy some shopping along the way. Then when they meet, they talk their way, and then they'll be able to resolve the issue that was at hand. So these are the modes of dispute resolution that we have. Probably if I can give the advantages that we have, number one, talk about efficiency. From the example I've given, have you seen it becomes a very efficient way of resolving disputes? Is it expeditious, like the time involved? Is it fast? Okay? Number two, cost effective. I know I've been talking about each and every party going to a lawyer. But remember, here we have gone for a lawyer for just inquiry, and he has been able to tell you that do this and this and this, and then the dispute will be over. Probably you just spend 5,000 consultation, the dispute will be done. Compared to the normal scenario whereby you go to consult a lawyer, then he tell you open a file, then he tell you pay for this, pay for that. By the end of it, you'll find that actually probably even the case, you are not good in the case, you get slapped with the cost, you pay the other lawyer, you also pay your lawyer and all other costs and all other expenses that are included. So ADR number two is that it is very cost effective. It is time saving, as I've told you. It is friendly. It maintains the relationship that we have between our communities. When an employer and an employee get involved in a tussle and then they resolve, for example, taking through a mediation, they'll be able to pay very minimal amount to the mediator and resolve the issue and even shake hands. Even when that boss will be able to see this employer back to work, the issue will have been resolved very amicably. Okay? So I think I'll be able to invite probably questions. We'll begin with Elder. We can have 5 questions, even top-ups to what you understand, and even live experience. I can invite Callaghan to take us in the next 10 minutes, probably. We can have a question and answer. If you have something to add, something to be clarified, you're welcomed.
I think in the course of your explanation, you've answered my question. I wanted to ask that what is the use of having a will if you can still challenge it again? You see, I decided that I should give my child 10 acres, this one 5, because this one is very rude. I'll give you 1. Now, you are challenging it, but I've gotten the explanation. It's okay. Thank you.
Yes, my question is that all these parties taking part in the ADR, do they have any professional background? Do they have any information? Unlike the lawyers and those who have been trained in this. And how do we avoid the biasness?
Yeah, thank you, Elder, for that question. It is a vital question. There's another hand. We'll take Elder and then we'll take from her. There's a hand from Robina. Yes.
I think I came in a little bit late. I don't know whether you had answered it. I was asking a question on distribution of land, where the owner of the land has passed on, so it's a deceased person's property, and the sons and daughters are not agreeing. What would be the best option?
Thank you for that question. Let me take it from Robin and then I respond to those concerns.
Mine was more of a comment.
Yes.
I wanted to comment on what we said earlier. I think we talked about mediation, and we said that when there's mediation, we need an neutral person. So using the example of an employer-employee, if there's a dispute and you are to have mediation, I think as the employee, you are entitled to someone who's not your boss to be the mediator. Because then again, if it's your boss still being the mediator, or HR, someone who has coercive power over you, then it stops being mediation. So at any point, the employee can even challenge, we have been told to go to mediation. I'm seeing this mediation panel is still not neutral. I think that's something I wanted to bring out. Then there's a question Elder posed and said, in this conflict, employer-employee, can't the employer still coerce his way and get things going his way instead of the legal way? Surprisingly, that's the place where the law favors the employee. Labor laws mostly favor the employee because they realize the imbalance of power already. Yeah? So not unless it's a gross misconduct, which is actually stated in the terms of service, in the institution laws, not unless it's a gross misconduct. Then on that part, you also have the opportunity of using the technicality. I'm being fired on my first, something I've done wrong on the first time. Was there a verbal warning? Was there a written warning? How many of these ones have there been? So those technicalities can actually help you, so that you're saying a good standing person has done this one thing. Should they be terminated? Then that's where now the mediation and other things come into play. Yeah. So I thought to let you know that as long as you've been doing well, the labor laws really favor the employee, not unless you've been having issues. Thank you.
Thank you for that, Robina. Allow me to respond to the questions that have been raised. Now, one, on what Elder said, it is very critical that for every facilitator, be it an arbitrator, be it a mediator, negotiator, they go through training. In this country, we have the Mediation Training Institute. It's based in Nairobi. Majorly, it trains on all these facilitators because they have to be conversant with the laws they're going to apply, the resolutions, and how binding it will be for parties. So number one, it's not just for any other facilitator to engage in. So yes, they go through vigorous training, and there are also professional bodies that oversee them. So they don't operate in a vacuum. So you'll have to go through a training. Like for me as an advocate, I would like to go, if I want to pursue mediation, I'll have to be trained. Because for us, what we've done as LSK, we've negotiated with this training institute. They've given us a subsidized fee. So if I want to enlist for, let's say for being a arbitrator or a mediator, I'll pay a certain amount that has been subsidized. Then I get my certificate. And once I get my certificate, I'll have to be enlisted with the judiciary as a mediator or a negotiator or an arbitrator. And then I am licensed to operate as that. Now we have the entire list of negotiators, mediators, and arbitrators lodged with the judiciary. So therefore, you can liaise with the judiciary to inquire whether this one is genuine or not. Coming to the question that has been raised on this particular end, the issue of land is very emotive in this country. Very emotive. People don't agree. And therefore, if people do not agree on an issue, may say division of property and everything, they can now proceed to court, of whereby now a judge or a magistrate will be able to determine that particular issue. Because at times it's realistic. Sometimes people don't agree. Let's say you have about 50 acres. There's a sibling who wants about 20 acres and is looking out on the other siblings. They've not been able to iron out their differences. The court will now have to step in and distribute those properties equally, because they are beneficiaries of the deceased person. So where mediation fails, then the court will take it up and now do justice to every beneficiary, as long as you are a beneficiary to the deceased. The problem comes in sometimes we do not have evidence to prove that you are a beneficiary. Just like the scenario Peter was saying, you know, these other people will come in, the Mpango councils will come in, but they cannot give a direct link that they were depending on the deceased at the time of burial, or at the time when they were still alive. But the one thing that I said here, I should have been last year during such a time, as a person who's living, it's good that you plan your matters well. Write a will. That's the best thing you can do to yourself. Write a will, so that you avoid these issues of contestations in court. Trust me, we have matters that were filed way back in 1996. They're still active in court to date. Because when they're about to confirm of what has been agreed, there's another party comes in and says, I'm being left out, meaning total deceased. Or I'm a spouse to the deceased. So the best way, dear friends of Christ, when we are dealing with matters land and succession, write a will. Once you've written your will, deposit it with your advocate. It remains between you and the advocate and the witnesses to that particular will. It resolves a lot of issues. Friends of Christ, death is here with kifo iko. So we need to plan. Sometimes, sisi ni Wakristo lakini ikifika hapo we don't want to go to that particular area. Mimi mambo ya kifo sipendi. But plan for your family. Write a will. It's not a sin for you to plan. You can plan it. Useme, for my wife, I know my brothers very well. Atapata hii yake. For my daughters and my sons, this is what they will get when I die. And it's not contestable in court. We've had people who've written that clause, by the way. You contest, you forfeit your share. So wewe ukufanyia kazi and then you are being given maybe a percentage and then you want to go and contest uache share yako. Will you agree to that? There are some people in this country, we've never had contestation in their estates. Why? Waliandika and wakasema, if you're willing to contest, forfeit. So when your father worked, maybe the estate yake ni 5 billion. And asema out of the 5 billion, you get 1%. And you want to, do you think you touch 1% of the 5 billion, alafu ende kwa chini, which is 50-50? You'll either get it or even lose it. So will you go for that? No. To answer what Elder has said on the other end concerning the employer and the employee, and I want to bring us to attention when we are drafting or when we are signing our employment contracts, let's be very intentional about it. Sometimes, how those employment contracts have been formulated is where a lot of issues come in. Now, when you're dealing with the employment contracts, there's always a clause for dispute resolution. That particular clause is critical to you as an employee. Just like Robin has said, the Employment Act and the employment laws of this country, true, they favor the employees. But at times, sometimes, if you are not considerate and intentional about the employment contracts you get in, you get yourself messed up. So be sure with how it's been formulated, the ADR, the dispute resolution. Some of the employees and the employers will prefer that if there's a dispute, they refer to an arbitrator, agreed upon between the employer and the employee. So if that particular that one arbitrator cannot agree and resolve that issue, they say we appoint other two. They become two. If they cannot resolve, then it goes to the mainstream, to the courts of law. So that is also dependable on the terms of that employment contract. There's contracts that are silent on that. And that is why now the employer will get an upper hand when the employment contract that does not specify on ADR. But for you as an employee, you still have recourse in an employment and labor relations court. You can still find your recourse in that. So I believe the law protects and cuts across whether you're an employer or an employee. You still have a recourse, especially when there's a problem or a concern that is coming. Now, friends, this particular ADR we are saying this afternoon is very preferable, especially when we are for family members. It's for neighbors, those people with close relations. And that's why some of these courts, when they realize you're a brother and a brother, will tell you, we refer you to mediation. Why so? They want to restore the relationships, the cordial relationships. You know, sometimes, let me tell you, going through a court system can be very brutal, especially if it's your brother. You'll never be the same again. The relationship will be destroyed. So at times, the court will want to look, it will want to keep in touch or retain the relationship that should be between them. So the court will want to identify whether these two are related. Are they from the same neighborhood? Are they like we are brothers and sisters here? So those are the things that we want to do. So part of the objective of the ADR is to maintain cordial relations so that we do not go to those extent that we cannot repair our relationships. Some of us have built relationships within our families. Hatutaki iharibike. Tunataka ikuwe at least intact. Sometimes that is why now ADR is in to restore some of these things, dear friends of Christ. Now, I don't know whether we have any other question. Yes, Obed.
I have two questions.
Yes.
Number one, what about for those of us who are in trade business?
Yes.
Where you are involved with salesmen. So unapata your salesman ako na deni yako ya more than 300,000 na iko nje. So how best can you do that in terms of you cannot fire this guy because you know anaweza enda na deni yako. On a second matter is ADR limited to just or even it extends to banks? I'm talking about auctioneers. Mm-hmm. I recently saw a video in X, I think last week, where someone was harshly mistreated in the streets, akanyang'anywa gari yake in the streets. So as people who know the law, what is the best way, or rather, what really happens so that when auctioneers, so that you know your rights, and also when the banks or rather auctioneers have extended their boundaries? Thank you.
Thank you, Obed. Yes, there's a hand here. As I respond to Obed, you can bring the mic. Now, I'll start with the second question. In corporate governance or in corporate or under commercial, this is where now banks come in. This is where the insurances will come in. Yes, ADR can still be applicable in commercial entities. The commercial entities is like number one you said on the bank. And I know banks right now, they're uptaking the ADR. They have with them their internal systems that can resolve issues. So yes, we can have ADR in commercial entities like banks, insurances, and other private companies. Yes, that can be still be effected. And number two, on the issue of auctioneers. Yes, you can have a conversation with auctioneer and have a mediation with them or an agreement with them. But when you're doing that, you know that is already a court process. Because by the time the auctioneer is getting onto you, a court of law should have decided on that particular matter. They are at the execution stage. They are getting the money. So it means you are sued but you were not aware, or you were sued and you ignored the court processes. So therefore, it went all the way to the execution stage, and that is why auctioneers were being invited or are being appointed to execute a decree for money that has been initiated by court. So it means that is a court process. So you need to understand what you're getting into. Number one, get to know what is the case number. What is the amount involved? Who's the party suing me? Because the auctioneer, they do not appoint themselves. They are being appointed by the aggrieved party who has moved to court and proven to court that you're owing them. So by the time they come to you, you need to look for the person who's sending these auctioneers. That is the aggrieved party who has moved to court, and they've been able to establish that you are owing, and they need to apprehend your properties to realize the debt that you're owing. And then on the issue of the salesperson, you as the person, you can also initiate ADR with the person. You can find a neutral party, invite the salesperson for you to have a discussion. But this is my advice. You'd rather have a service agreement or a service contract with your salesperson, so that in case they default, then you can opt for ADR or opt for a court system. That is what I can give you for that. Because there are also service agreements for salespeople, and they are there. So you can have it, and therefore everybody will know the obligations and responsibilities. But if you've not done that, you can still engage a neutral party, a facilitator, for this case, an arbitrator or a mediator, for you to have an agreement with the salesperson. So the sole purpose of you redeeming your amount. But that if that fails again, you still have an alternative. You can go into court as long as you have evidence to prove that this amount is being owed to you by this particular salesperson. But you need to also prove there was a relationship, a business relationship between you and the salesperson. So that is what I'll advise in the given circumstances. Yes.
Mine was a follow-up question. You talked about the will,
Yes.
setting up a will. Where I work in insurance, I encourage my client to set up a trust
Yes.
for their estate planning. So maybe you can discuss the differences between the two, because where I sit, I say the best option will be setting up a will because it is not contestable in court. Maybe you can give more light on the difference between a will and a trust.
Yes. Now for a trust, there's a law on trusts. And I thank you for bringing that in. There's a law on trust that governs that if you have minors in your house, maybe you will dictate and say, if I die before they attain the age of majority, which in this country is 18 years, then someone will manage their assets until they attain the age of majority. And the same will be distributed to those. And then so you also specify that as long as they will be still in school, their school fees will be catered for. Now, what happens, the difference between this trust and the will? You know, for a will, it's immediate. But for a trust, you have to attain. So if you had enlisted your beneficiary, and maybe you pass by the time, let's say he's 5 years old, Ama she's 5 years old, Ama is 5 years old, either, they will have to attain that particular age of majority. So it's not automatic. It is a process. They'll have to wait until they attain, they come, they are verified, and then it's now translated to them. But for a will, it should be, after the same has been done, it's just automatic. You get your rightful share or the portion that has been allocated to you. So that's where the difference comes in. So you may want to decide based on your own capabilities and how you know your own people, that if this the trust that will be beneficial to them, sawa. But if you're seeing that for the trust will take time and the time duration will be long, you can appreciate that also. Wacha iende automatic. But now the challenge comes in, especially when you die and maybe you leave a young one, you also need to live under the care of somebody so that at least they manage that particular property for him or for her until the age of that majority, and that is when you can transist to them. So I hope you get now the difference between these two. This one is manageable for that particular period that has been specified under that particular trust. So if it's 10 years, it's 10 years. But if for a will, that is automatic. If I've been told that I'm getting the car that my dad has been driving, it should be automatic. Once it's been read out, I do the transfer. It's mine. But if he's saying that I will not attend that vehicle until at the age of majority, I still have to wait until.
Not necessarily.
Yes.
For a trust, when you set up a trust, you can still specify that if I pass on today,
Yes.
there are different things. There is school fees, there is upkeep.
Yes.
If there's a vehicle, it will be distributed immediately.
Yes.
Maybe my question was, because we normally say that a trust cannot be contested in a court of law.
Yes.
It will fall up the way it was set up.
Yes.
But a will can be contested.
Yes. Now,
Is that the case?
the issue was, if you remember for the will, like I said, you know the will is you who's specifying. There are people in this country, I don't want to mention for security issues. There are people notable in this country, number one, they've had to put clauses in their wills that is not to be contested at any level. What has been given is what has been given. So if you put that clause in your will, it remains so. So it has a condition. But if you write a general will, it will be contested. If you write a general will, it will be contested. But for wills, when you're writing a will, make sure that you provide for every beneficiary. Now that's where the catch comes in. A lot of people don't want to disclose who their beneficiaries are in the will and the properties they own. So you realize that people have listed properties 10 in a will. But in a nutshell, they have about 15. So where is this other 5 that has been left out? You realize, for us as men, sometimes you have 5 children. But in the reality sense, you have 15. These 10 will come. Trust you me, these 10 will come. So the best interest is, you list all your beneficiaries, list all your properties, and allocate. And if you want to put that clause for non-contestation, you can still have the liberty to do so. But make sure that you've made a provision for all your beneficiaries. And you've listed all of your properties and all of your liabilities. Madeni yote uko nayo unaweka hapo. So that if I'm knowing that I have a loan at KCB, it should also be sorted. Because KCB will come after the estate saying they were given this. And like you're saying, which is true, for the trusts, it's under the procedure that is been given. So if you have an issue, then you look at the trust manager and then you ask, and they will be able to guide you on that. Any other? I'm saying we've really spent on this. Yes, Abongo?
Not a question per se, but an observation.
Yes.
Now, without mentioning names, because you come across quite a number.
Yes.
I want to just pick it from the last example you've given, where one has quite a number of beneficiaries and an extension of property. But then, because they want save face and also the dignity that they have earned in the society, so they become very explicit or candid in their writing that he or she has written explicitly that I so and so.
Yes.
Upon 1, 2, 3, then this and that be followed.
Yes.
But then you get to hear some stories that these are the families or these are the beneficiaries. They've had history with them and they were well taken care of.
Yes.
So in legal space, do you have provision to handle these two scenarios? Because if you look at human behavioral patterns, there must be something that informs one to behave the way he or she is behaving. So then, how do we become accommodative so that we don't just see everything in one cut, that we are all straight in the law, but then socially and in human nature, one want really bring peace.
Yes.
I hope Mzee Kirwa ananipata vizuri. Yes, unataka kuleta amani, si mgogoro. Yes. And you are saying that, okay, this is already set and there is no problem. But huku nyuma, he or she also handled the matters in a way. So can you have two wheels, like that, or in any other thing. I'm not trying to bring, some confusion in the sort, but I'm just trying to apply my mind in whatever has been fed to us of this dispute that come out. And we really need not to say that those guys did not know what they were doing or were not wise. I don't know.
Thank you. We've had scenarios, as I conclude, we've had scenarios of where we've had even more than 3 wills in one estate. And the estate I'm saying is where the person has died and have left the properties. That in law we call it an estate. Now, you know what the court will have to do? All those wills will have to be revoked. Because everybody is contesting. And there are 3 wills here. There is no way you will have will 1, will 2, and will 3. So what we will have to do, the court will have to look at the wills and the party who are contesting or are disputing on this will. Then they'll have to make a determination and say, number 1, we'll have to revoke. And it's either the court can do that or the party will have to do it. It's done on the initiative by the court or the parties to the dispute. They can move to court and say, look, we have 3 wills. There is no way our father would write 3 wills at a go. Let's revoke all the wills. The court will have to look at it and say, yes, let's revoke at all. Then revoke. So we are at odd and even level. Then we start to determine who are the real beneficiaries of the deceased person. Once then that has been established, we establish the mode of distribution of the properties. Then we distribute. So the key here is, when you're making your will, when you want to make changes to your will, you can still make changes to your will. If you made a will in 2023 and you want to incorporate a will in 2020, revoke the one for 2023 and make the one for 2025 stand now. That is what is advisable, so that we don't have the issues of having multiple wills. So if you've acquired properties in 2026 and you remember the last time you updated your will was in 2021, for a span of 5 years you've amassed wealth, what you do, you revoke the one in 2021, write another one, update another one, and revoke the other one, so that we do not have instances of separate wills. Now, the problem is sometimes we do not know how to keep quiet with some of this information. You've written a will, and I come and say, you know, I've written a will. So if you mess around, so people will start to identify where did he deposit this will. They will realize it's without a particular advocate. The advocate will be told they will be compromised if he is not a Christian.